The CPI report, Child Protection in Iowa, brought to you by Vocal, Victims of Child Abuse Laws. Vocal is ready to assist families who encounter difficulties with DHS in the juvenile court. CPI stands for Child Protection in Iowa. Vocal can help with your DHS issues. Vocal is telecast on Mediacom Channel 17, Sunday afternoon at 1 o'clock, and again Wednesday evening at 8:30. You can contact Vocal by email, vocaliowa@mchsi.com, or you can call for helpful tips from Don Burgmaier, area code 515-276-3956, or John Harvey, 515-282-2672 in Des Moines, Iowa. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report, CPI, Child Protection in Iowa. And in two areas we attempt to focus upon needs in this general vicinity. One is influencing public policy as it relates to those issues. And secondly, it is our intention to give first-hand assistance to people who have difficulties with the Department of Human Services and the juvenile court. We do not represent ourselves as practicing law or representing you before any court or magistrate of any sort, but we give you an idea of how to conduct yourself in the court of law. And by the way, there's all kinds of areas in which rulemaking areas, such as family court, the divorce court, the juvenile court, the criminal court, and one unusual one, and that is in the administrative arena. And that has to do with the rules by which the agencies are governed. And guess who gets to make the rules by which the agencies are governed? Why, it's the agencies make up their own rules, and those rules are supposed to give you guidance to protect yourself. They're supposed to assure that there is a full expanse of due process rights conferred upon you, and it is a super idea that you should know all of the rules, or should know a good deal of the rules that you may be called upon to operate on in any of the judicial venues, we call them. One of those venues is called the administrative arena, and if, for an example, you don't like what an agency has done to you or to your family, you have appeal rights. If you're an aggrieved citizen, you can go to any agency that has done something to cause you grief. And you're to have a full-scale hearing, fact-finding hearing, and then the agency makes a final decision with respect to your case. Once you get that final decision, if you don't like it, if it's a decision that you feel merited far more attention because they left out facts, or if they misused the law in coming to a conclusion, you have the privilege of taking that then into district court for review. Well, I've been looking over some of the rules by which the Department of Human Services functions. it receives about 37,000 phone calls. And many of these phone calls come in from drunks after hours. They've got a chip on their shoulder and they want to turn somebody in for child abuse. And that initiates a process by which social workers have to check everything out to be sure that every child in Iowa receives maximum safety, and based upon some of the most inane accusations, irresponsible accusations by people who don't even have to identify themselves. So they're only too happy to listen to 37,000 phone calls, even if some of them are pure junk. Well, so from that process, there comes a decision made as to whether the accusation is valid and whether they can found a report of child abuse. Or they can unfound it, say that there is not sufficient reason to believe that a child has been abused. In both cases, it's placed on the registry. And there's a purpose for that, because they want to identify not only an abused child, but they want to identify the alleged abuser. And both of them get watched over by a compassionate agency whose goal really is to harass the living daylights out of them. Well, that basically is what happens. However, of that 37,000 phone calls they get, many of them, a large percentage of those calls, are called rejected reports, because it has to do nothing with child abuse. They just don't, grandma just doesn't like the way the grandkids are being raised. Well, she can call the hotline, and that causes a social worker to take time out to check to see if the grandkids are being raised properly. If she finds that on an initial phone call that there is not sufficient evidence, or there's not sufficient reason to believe that a child has been abused by a caretaker, then it falls into a stack of called rejected reports. Something happened here just 2 or 3 years back. They want to keep rejected reports on the system. And you know that when an agency wants to keep thousands of files, it means thousands of file drawers. It means thousands of hours to gather those reports and put them in decent form, put them on the computer so they can track them, and basically they want to they manage somehow to get those reports tracked for 6 months. Aha! They found out that if they could get it done for 6 months and do a good job of it and enhance the safety of children, perhaps they ought to keep it for 3 years. So recently, the Department of Human Services has decided that it will keep rejected reports for 3 years. And they put that in what they call Administrative Rules Committee report. And this particular report, let's see if I can find it, it's called ARC 8209B, as in bad. ARC, and seldom ever do I look over administrative rules. They don't follow the rules anyhow, but it's good to keep an eye on what the department is doing from time to time. And before I forget, I'll also have to tell you that apparently they felt they weren't getting enough reports of child abuse, in just the ordinary run-of-the-mill stuff. Now they're begging for reports from people. Even though there isn't child abuse, there may be some other reason why the juvenile court might like to look into a case because there's something suspicious about the case and that the child needs the assistance of the court to take care of him or her. So now they're accepting reports. In addition to those 37,000 child abuse reports, they want to have reports on to investigate the possibility that the juvenile court might want to become the temporary parent of any Iowa child. So beware, you may get snatched as a parent on child abuse, but even if you can meet all the demands and get through that child abuse area, you're still not out of the woods, because they're going to nail you one way or another then with an investigation which will let the judge decide whether your parenting is appropriate or not. Don?
You were talking about DHS trying to generate more reports. 20 years ago, you remember there was a DHS worker here in Des Moines that read the newspaper every day looking for an article that had anything to do with a child or family, and then he'd write up a report on it. So they look for all kinds of ways to generate reports. Even if there's no truth in it at all, they'll put it on the registry anyway.
Sure. Anyway, to have more and more reports, because the more reports, since this whole thing is called labor intensive, in other words, if you double the number of reports, that means you'd have to double the number of hours to take care of those reports, wouldn't you? If you were doing a good job with each report, you'd want to double the number of hours if you double the number of reports. Now, it doesn't make any difference the quality of the reports, just the quantity of the reports, because that's what builds influence, that's what builds staffing. And I'm not sure that we should be going out at this time and looking for ways of expanding our DHS staff. How ridiculous. So, as of November the 10th, the Human Services Council, that's the policy-making board, ruled on advancing this particular rule so that they can keep rejected reports. Now, rejected reports have the value of leftover spit. I cannot understand how a child's safety is enhanced by maintaining a report coming from a drunk in the middle of the night who anonymously calls in, and his report doesn't even fit anything in statute or in juvenile court law, and is so bad that it doesn't fit even the most liberal point. Well, guess what? John Harvey opposes as of November the 10th. I rise to oppose enactment of Administrative Rule ARC 8209, B as in boy, to change the retention period for records of rejected child abuse intakes from 6 months to 3 years, and to establish that records of rejected child abuse or child in need of assistance intakes shall be retained for the same amount of time. An abundance of telephone calls leading to child abuse investigations pursuant to a China or court intervention come from anonymous sources. One individual speaking before a legislative session testified that the calls delivered to an Eldora call center after hours were considered to be under the influence of alcohol. Well, thanks for those reports because you keep the social workers busy. The DHS has refused to cooperate with a legislative recommendation rising from an ombudsman's investigation in which he advised the DHS to provide for a centralized intake unit. They don't want a centralized intake unit because somebody could find out that they're not doing their job. They're not protecting children, and that they have one social worker sitting up all night long to listen for drunks who call in each of the judicial districts. Can you imagine someone assigned to that job? We need lots of people to do that. Well, one team could do it for the whole state, but they don't want to give up their little kingdoms, their little geographic fiefdoms. A rejected telephone report simply means that there is no merit of any sort recognized by statute giving jurisdiction to the department to investigate or to take action of any kind. The sum and substance of such a call amounts to zero merit pursuant to the safety of any Iowa child, and there can be no valid showing that extensive, careful preservation or any effort to carefully preserve irrelevant data gathering from anonymous, non-meritorious sources can somehow favorably impact the safety of a child. How do you take junk data and use it to enhance the safety of a child? You can't. But common sense doesn't mean anything to the Department of Human Services. Adding more employees does. Okay, it is an expensive administrative nuisance for state workers to preserve data which is not prescribed by law to gather in order that by some evolutionary process, nothing could become something. Helpful to the DHS if that bad data was permitted to stew for up to 3 years. If it's bad in the first place, it's probably going to be bad in 3 years. If it was not useful initially, it probably won't be useful during the 3-year period. But in the meantime, we're wasting a lot of money. The process of gathering irrelevant data is an invasion of one's privacy when there is no substantial due process means of validating the source. The person named in the allegations has no adequate method of having his day in court to prompt expungement of the information and to access and to take measures to cause the false allegations to cease. In other words, if people are doing this maliciously, if it's anonymous, it's pretty hard to cause a cessation of that nonsense. A citizen of Iowa must have the right to argue all issues of data gathering, of the data that's been gathered, which name him as a potential perpetrator of an offense against a child. Since child abuse is a serious public offense, each citizen must be charged only upon a sworn-to affidavit of complaint with full disclosure of the source. If the proposed measures were appropriate and in keeping with legislative intent, it would certainly be imprudent at a time of serious economic distress to initiate such an expensive and unproductive procedure, preserving, storing, and tracking data which has the value of garbage. Handling of paperwork and the tracking of reports is inherently labor-intensive. Creating labor-intensive procedures at a time when the agency is called upon to reduce its staff is totally absurd. What if they get all of these requirements? And by the way, when that's put into law, that becomes a requirement for the department to do. If they're adding all kinds of requirements and their staff is reduced, how will the things that need to get done be done? Good question. And why should we be spending big bucks on something like that? Well, some of those things are happening in a venue called the Administrative Appeals Area, or Administrative Area, DHS. It's called administrative, and it's under the executive branch of government, and it's encroaching upon a relationship, a too tight of a relationship with the juvenile court, which is the judicial branch. And we have a gentleman who speaks about the judicial branch, a branch of government which, like the executive branch in DHS, needs to be reformed. In order to enhance our knowledge about the problems with the judicial branch of government and court reform, we call upon Terrance Walker. Terrance?
Thanks a lot for the eloquent introduction, as always, John. You do me more justice than the courts could ever give me. Um, anyway, I think that the whole thing with judicial reform is impinges. I think the key issue in judicial reform is the whole idea of judicial immunity. Once judicial immunity is removed, then I think the courts will fall in line. Might not be fast, but it might not be complete. But I think that is one of the key impediments to having a judiciary that is truly fair, that will truly treat everybody equally, whether you have a high dollar attorney or not, whether you are what color you are, no matter what background you are, no matter what orientation you are, no matter what sex you are. That's one of the key impediments, I think, is the whole idea of judicial immunity.
From
Well,
what source would come the greatest amount of resistance to erasing immunity?
well, of course, the judiciary. If they're the ones that's dead set on this immunity, then of course they're going to give you the most resistance to trying to change that, which is why I feel that it is unlikely source to file a court action to try to get the immunity removed, because more likely than not, you're going to get laughed at.
How
Might
about,
get laughed out of
how
the
about
court.
prosecutors?
Prosecutors. That's my next thing. Prosecutors. Now, there is a case here. Let me back up. Prosecutors also have a certain amount of immunity unless they are tied directly with the investigative stages of a specific alleged crime. Um, the crazy thing is, here in America, we have a justice system whereby the prosecutor can bring charges against someone wrongfully. The judge can act out maliciously and do things outside the bound of his authority, as long as he's in the courtroom doing it, and he can have immunity. And we call this a modern free society. Now, I don't understand how this could take place in this day and age, but we've got people that have been wrongfully sentenced, wrongfully prosecuted, and nobody, as far as the prosecutors or the judges, will, under the law, in most circumstances, be held accountable because of this whole idea and notion of immunity. Well, back in communist Russia, you could get thrown in jail wrongfully, convicted wrongfully. And this was supposed to be such a bad thing there, but here in this society, 2009, we have lawyers and judges and prosecutors arguing that this is okay. Well, I don't think it is okay. Prime example, we have a case that emanated from here in Iowa, good old Iowa, which has made it all the way up to the United States Supreme Court. And a few of you might remember this case. It involved a guy by the name of Terry Harrington and Curtis McGee. two individuals out of the Council Bluffs area. They were both about 17 at the time. Matter of fact, Harrington, when he was arrested for it was a murder, he was 17. He was captain of his high school football team and being recruited by the likes of Yale for his skill. Less than 2 years later, he was convicted and sentenced to jail for a murder for life without parole. And this case had been overturned about, was it about 3 or 4 years back? 3 or 4 years ago, a lady by the name of Ann Danaher helped work on the case and invested some of her, a lot of her money and time to help contribute to the defense of Mr. Harrington, and eventually was able to demonstrate in court, and in which the Iowa Supreme Court agreed that the conviction for murder should be thrown out. And these guys served a total of 25 years each in prison, and based upon the facts that the prosecutors withheld evidence, exculpatory evidence which would tend to lead to exonerate you. The evidence was that there was another suspect that was being investigated that was a brother-in-law to the fire chief of police, or the fire chief in Council Bluffs, and that whole thing was kind of not even presented to the defense attorneys. And the defense attorneys are supposed to have all the information that the prosecutors have. They are supposed to basically get all the investigative information, all the leads, anything that's going to tend to show that they're innocent, that can be used as a defense. Well, they didn't do that. Matter of fact, the prosecutors have basically had tried to basically frame these guys, and they did so, and that's why they served 25 years in prison here in Iowa before they were freed, and the Iowa Supreme Court luckily allowed them to be freed. Did you have something to say, John?
DHS does that same thing against parents. They
Yeah.
have the evidence and hide it from the court and tell the lies.
Yeah. Yeah, and that's why we have this show, to show that the DHS and the judiciary need reform. One of the key issues brought before the United States Supreme Court last Wednesday on November 4th was whether the prosecutors who work side by side with police at the investigative stage of a case are also immune. Even though the police are not. The police are not immune. They could be sued for fabricating evidence. So why then should the prosecutors be free? One of the lawyers for the prosecutors says that, well, what you have is that everyone who believes that they've been wrongfully convicted will file lawsuits, and prosecutors will do nothing all day but defend themselves against meritless litigation. Well, that's false, because you cannot pursue a lawsuit unless you have the conviction overturned, and that rarely happens. Less than, well, I would venture to say less than 0.1% of the time. I don't think the Iowa Supreme Court reverses more than 1% of the things that it has before it when it comes to the criminal aspects. So that's a big lie. The one thing that tickles me is, and this is what the lawyers always tend to do, especially for the state, they want to reframe the whole argument and saying that there's no freestanding constitutional right not to be framed. Well, that's not what he's arguing. He's arguing that the prosecutors who are connected to the investigative stages in which the police are involved should be held liable. The Constitution does a lot of things. It's supposed to protect us against prosecutorial misconduct. So that's really an issue that doesn't have any bearing on the whole case. A question that shouldn't even have been phrased that way, but this is what they try to do.
It's creative framing, isn't it?
Creative repositioning.
Right.
They do this a lot. Couple of the justices in the oral arguments last Wednesday, one Justice Kennedy pointed to a 1993 Supreme Court ruling that said prosecutors can be sued for their actions before charges are filed. That helps out Mr. Harrington and Mr. McGee. Justice Sonia Sotomayor, who spent 5 years as a Manhattan prosecutor, also seemed unsympathetic toward the prosecutors. Why can't you separate the fabrication of evidence pre-trial, she asks, from the use of evidence at trial? And she is a former prosecutor, so she wasn't feeling sympathetic toward the prosecutors at all. And the lawyer for the prosecutor says, well, because it all leads to the wrongful conviction at trial, and under established law, a prosecutor is free to willfully bring criminal charges based on good evidence, bad evidence, or no evidence at all. I would argue that that is that is a stretch. If they don't have any evidence at all, then they don't have any business bringing any charges against anybody.
Right.
But this is what idiocracy does, and this is the whole basis for judicial and prosecutor immunity. It doesn't make sense. The people arguing for this, they do not make sense. So you're going to tell me that you can go and not have no evidence against you whatsoever, and a prosecutor can go and file charges against you? That is insane. And this is supposed to be America. There was a number of other entities, including the U.S. government, that also appeared to argue, siding with the prosecutors in court. The U.S. government, represented by the Deputy Solicitor General Neil Katyal, asserted that there is no constitutional right not to be framed. Again, there's that reframing of the issue by saying that you don't have a constitutional right not to be framed. He says that if prosecutors are immune, and Justice Scalia asked, if prosecutors are immune, how do you get the policeman who has fabricated evidence? Sanders replied that the policeman is liable because he's passing the fabricated evidence onto an innocent prosecutor. Now that's a bunch of bull. So they're saying basically that the policeman can fabricate the evidence and just hand it over to the prosecutor, and he can kind of nod and wink and just ignore the inconsistencies thereof. That's not a valid argument. And I know there are some situations that might occur, but Harrington and McGee present evidence that these prosecutors knew that there was another witness that they had investigated. So that doesn't have nothing bearing on this whole case. One last point I would like to bring up, and this is what Harrington says. He said, "This is what I was looking forward to. Being right here, right now, today, is what kept me in prison. Kept me all those 25 years in prison." Now, the whole thing is this: if we have a justice system that allows misconduct to incur, then that is not something that I would consider a true justice system. There is no justice in allowing injustices to occur. So I think that the United States Supreme Court has to do its job and actually setting forth the parameters and the bounds for what prosecutors can and cannot do, and not be held accountable. I think they should be held accountable, especially in this situation where they clearly knew that there was other suspects, and they didn't bother to even pass that information along to the defense attorneys. And two men, Terry Harrington and Curtis McGee, spent 25 years of their life in prison. I mean, they could have had scholarships, education, family, kids, all of that. had been stalled for that complete time frame, and I think that's a severe injustice. And I think to anyone that any entity or any lawyer arguing for the contrary is a fascist. But that's my whole 2 cents on the issue. Did you have anything to say, John?
One of the things that I think is regrettable with the expansion of this immunity business, which, by the way, is an open invitation to irresponsibility and non-accountability, is it not, Terrance?
Yeah, it is, and that's what I think is the key impediment to
Right.
judicial and DHS reform, for that matter.
Correct. Now, were you aware that a social worker who works together with a judge, and those relationships are being built all the time now, that relationship is such that the social worker can claim the same immunity as the judge?
Well, it wouldn't surprise
now-
me that they're trying to do the same thing in that spectrum. I mean, we face, the same issues as it concerns the judiciary and the DHS. It's just that the judiciary can back up the DHS and actually compound the problems of ineptness and bureaucratic malfeasance, I should put it.
Right.
But it's what goes on,
Isn't that
unfortunately.
Isn't that the truth? It seems to be no end. If people want to claim the right not to be responsible and pass that off to all of their friends and their coworkers, can you imagine what the end of that's going to be? The end of that certainly is not going to be justice, is it?
Like I said, it's going to be injustice.
Yeah, yeah.
So we have a injustice system that allows for these sorts of things to go on. I mean, you cannot call it a justice system if there is injustices that occur at the fundamental level, and that is a fundamental issue. How do we allow? I mean, how can we allow the prosecutors and the judges to act in such a way and be, basically be free from penalty? That doesn't do anything but encourage the behavior. And when you don't have any checks on that, then it's not going to do anything but proliferate. And that's where we're at today. That's why we have so many people in jail. That's why we have so many people with their children being taken, because the system is getting out of control.
Rotten system which doesn't have as its central core accountability. And something I thought was rather chilling about what you said here about repositioning, that because the Constitution doesn't strictly prohibit framing a citizen, tell me what is it in the mind of the prosecutor if he tries to frame somebody? He is obviously intends that person not receive justice. And I thought that the two-word job description of the judiciary is to do justice.
Well, there are two different constitutional violations that I can name out specifically that they would have impinged upon in this situation. For one, they impinged upon the use of perjured testimony by the prosecutor. That is a clearly defined constitutional violation, which the Supreme Court has named out a number of years ago. And then the other constitutional violation that they clearly impinged upon is a due process right to get all the exculpatory evidence, which is evidence which would tend to exonerate you and that you can use in your defense.
Sure.
So, by them saying, "Oh, there's no constitutional right not to be framed," No, there's related constitutional provisions with which protect you, and that's I'm sure that's the way they phrased their whole civil rights lawsuit
Sure.
against the Iowa prosecutor. So they're not doing anything but playing word games, and trying to split hairs in order to make it seem like they're free from liability. But in all actuality, they shouldn't be. They're a part of what's wrong with the system.
Correct. Well, appreciate your commentary on this McGee Harrington case and the background illustrating how Iowa officials want to do away with constitutional rights. Okay, Don, there is a lady who is outspoken. Well, there's a lot of ladies. That doesn't narrow it down, does it? But there is a lady in Georgia who is very outspoken in the problems that parents are having. Would you tell us a little bit about that, and then lead us into a videotape of her discussion? Don?
Okay, thanks, John. As you see on the air, we got a picture of her. Nancy Schaefer. She's from Georgia. The title is A True Enemy of CPS. We Love Her. August 27th, it was written. President of Eagle Forum of Georgia and Eagle Forum's National Chairman of Parents' Rights spoke at the World Congress on Families in Amsterdam, in the Netherlands, on August 11th, 2009. Pro-family leaders and groups from 63 nations attended the World Congress of Families. 900 delegates were Dutch and other nations represented, included the United States, Canada, Mexico, Venezuela, Chile, many others, including the Philippines. More than 3,000 people around the world watched the live telecast via the internet. On August 16th, Schaefer delivered via cyberspace her space to the Nordic Committee for Human Rights in Sweden on the protection of family rights in Nordic countries. Schaefer spoke on the unlimited power of Child Protective Services, that's CPS, or /DHS. She told her audience children are seized unnecessarily from their families due to federal aid created in 1974 entitled the Adoption and Safe Families Act. It offers financial incentives to the states that increase adoption numbers. In other words, money, dollars, dollars, dollars. To receive the adoption incentive or bonuses, local CPS must have more children. They must have merchandise that sells. This is an abuse of power. This is a lack of accountability, and it is a growing criminal political phenomenon spreading around the globe. Nancy Schaefer wrote a scathing report on the corruption of Child Protective Services while serving as state senator of Georgia. To read or get a copy of the Schaefer report or her speech in Amsterdam, please visit the Eagle Forum of Georgia website. This is the website, www at, all one word, it's eagleforumofgeorgia.org. Eagle Forum of Georgia. If you want to help reform CPS, they're asking for help. And you want to stop child trafficking, contact Eagle Forum of Georgia. This is their phone number if you want to give Eagle Forum a call. 706-754-8321. I'll repeat that number. 706-754-8321. Or you can go on the website at www.eagleforumofgeorgia.org. All right, John, you've got a video that she has produced.
My name is Nancy Schaefer, and I'm from the state of Georgia in the United States. And thank you for your gracious invitation to join you tonight, and thanks to all of you who have made this incredible World Congress of Families number 5 in Amsterdam possible. It's a privilege for me to join you tonight and to be with you in some pro-family policy here. I will share with you on the unlimited power of Child Protective Services. I served in the Georgia State Senate, and after 4 years of viewing the ruthless and unsparing actions of Child Protective Services, also called CPS, which I will use tonight, I wrote a scathing report entitled "The Corrupt Business of Child Protective Services." Thank you. The report cost me my Senate seat. Here's some copies of the report, if you'd like to get one. However, there are causes worth losing over, and this is one. I'm going to talk about some of the problems and then some realistic, maybe, solutions for families and children, and maybe look to some steps that we can take. This is not to say that there are not those children in wretched situations who need to be removed. There are, and we all agree. But tonight, I'm talking about those children removed from their homes intentionally for profit. Children are seized unnecessarily from their families due to the federal aid created in 1974 entitled the Adoption and Safe Families Act. It offers financial incentives to the states that increase adoption numbers. To receive the adoption incentives or bonuses, local CPS must have more children. They must have more merchandise to sell. Funding is available when a child is placed in a foster home with strangers or placed in a mental health facility and medicated, usually against the parents' wishes. Parents are victimized by the system that makes a profit for holding children longer and bonuses for not returning children to their parents. This is abuse of power. It is lack of accountability, and it is a growing criminal political phenomenon spreading around the globe. Oftentimes, but not always, poor parents are targeted to lose their children because they do not have the wherewithal to hire an attorney or fight the system. Being poor and lacking proper housing does not mean your children should be removed. CPS has redefined poor to mean psychologically inferior. Therefore, it is in the best interest of the child to be removed. Best interest, of course, has also been redefined at the child's expense. It has been reported over and over that 6 times as many children die in foster care than in the general public. Once a child is legally kidnapped and placed in official safety, the child is far more likely to suffer abuse, including sexual molestation and or rape. Case workers and social workers are often guilty of fraud. They withhold and destroy evidence, and they seek wrongly to terminate parental rights while being protected by state immunity. There is a huge bureaucracy made up of judges, court-appointed attorneys, guardian ad litems, social workers, state employees, court investigators, therapists, psychologists, psychiatrists, foster parents, adoptive parents, and on, who are looking to the children in state care for their job security. Judges have control over private living arrangements and income of 48.3 million Americans. The United States Census Bureau reported in 2002 that 40 billion in transfer payments were made between households of custody parents and other parents. That money, 40 billion, is under the direction and control of family court judges in environments covered with confidentiality laws that protect the wrong people. Fathers are victims of this unjust system. Child support payments, even without having visits with their children, are choking the very life out of fathers. 3 fathers, of whom I am aware and have been in touch with, committed suicide in the last 12 months because they lost the opportunity to even visit with their children. These are crimes against humanity for financial gain. Rights are removed from parents, human rights, civil rights, and even religious rights. One illustration of what took place in my district is that after so many calls, I decided to call a meeting in one of the counties of my own district. I personally called 37 families that had been in touch with me who had all lost their children, grandchildren. I had them meet me in the library one Saturday morning. We started at 9 o'clock and we ended at 9 o'clock. We had 50 families standing outside the door that could not get in. We didn't have time to talk with them. There was incredible anguish and profound suffering from these families. Some children had been taken off the school bus, taken out of the hospitals, or taken out of their homes in the middle of the night, and even worse. It was just an incredible ordeal. These parents, trapped in the system, become like refugees. They're dazed and glazed and have no one of whom to turn. They do not know what to do, and the loss of their children is devastating. After having worked in this arena for several years, I do not believe that a single child comes out whole after having been in this system. Many foster children make up the homeless population of today. I introduced legislation, Senate Bill 415, in my last session. A substitute bill was written at the last minute by the chairman of the Judicial Committee. All the strong points of my bill had been compromised. I was told, accept it, Senator. At least you will get some legislation passed. And I answered with, obviously, you do not know me. I did not come to the Capitol to get legislation passed. I came to make a difference. What can be done? An independent audit should be called on every state of all Child Protective Services departments. I'm in touch with congressmen and state officials, and the door may be possibly opening very slowly. A federal congressional hearing is needed. But let me add, due to the hundreds upon hundreds of cases that I've been called to consider, I placed calls to state senators, representatives in their respective states across the country, asking them to help me with certain families. And I was told, if I help that family, or if I help you, I will lose my job. Remove, abolish the federal and state financial incentives, and those are taxpayer dollars. Those dollars have turned CPS into a business that takes children and separates families for money. Open family court. Remove the confidentiality laws. Give parents their rights verbally and in writing. I even feel that to terminate the rights of parents, the case should be heard before a jury. Family rights and parents' rights must be protected. We do not need more influence like the UN's Convention on the Rights of the Child. It's anti-parent, anti-child, and anti-common sense for the family. There has to be perseverance for any great reform, and great reform is needed in this area. As Charles Spurgeon put it, how do you tame a lion that is well fed? First, he must be brought down. Second, his stomach must be lowered. How do you tame Child Protective Services? It may be only by closing it completely and starting over at the beginning with pro-family values. In closing, let me remind you that there is case law from state appellate and federal district courts and up to the United States Supreme Court, all of which affirm the constitutionality of the rights of parents to actually be parents to their children. There's biblical law too. It goes like this: speak up for those who can't speak for themselves, and for the rights of all who are destitute. Speak up and judge fairly. Defend the rights of the poor and the needy. Thank you.
Well, there you have it from former Senator of the state of Georgia, Nancy Schaefer, who is speaking out on a subject that she couldn't get accomplished while being a senator, but she's certainly doing a fantastic job of serving families throughout the United States and speaking out for the protection of those families. Well, it's a shame that it's gone this far. We are not doing a good job of protecting our families here in Iowa. We need to be doing that. We'll see you next week.